H.
Yep. David and Houghton, appearing on behalf of the AG's office.
Mr. Thompson is representing himself, and I'm advisory counsel in this matter, but I can advise the court there is no other agreement.
All right, so Mr. Thompson is now here, making his way to the defense table.
Yes. Oh, sorry.
Just call me David, you're on.
All right, well, all right, so we are currently set, sure you can have a seat. Just as you may have heard me say earlier, don't take any thought. I have nothing to know about the case. I'm just going to tell you that, as I do to anyone here for a final pretrial conference. Today is the last date in which to enter a plea pursuant to any pretrial agreement. Any plea from here on out must be done by entering a plea as charged. The reason I do that isn't to punish the defendant, isn't to punish anybody or encourage a case to go in any one direction. It's just to encourage you all to exhaust any negotiating that you've got to do, because everybody's got to issue subpoenas. Subpoenas have to be served by police officers or process servers. My staff has to issue jury notices. 60 different jurors have to reschedule dates and times and take off work, and employers have to do the same thing. So again, there's no punishment. It's just to make sure that we have exhausted all of our negotiating skills. So we have no resolution. The case is currently set for a trial right now. I know we have two trials set for February 18th. Excuse me, this one is set for 1 day. The other one was set for 2 days.
And I was going to, on behalf of the AG's office, I think that they're planning on it, ask that perhaps we keep both of those on. The idea being that we'll be able to conduct both of those trials on that 2-day time frame there.
And was there a jury demand, I assume?
There was, Your Honor.
Right.
Okay.
The other file on the second day to do this case. So I'll issue jury letters to 4 sets, 4 panels, 2 for each day. So Mr. Thompson, that means that even though your notices say that our trial was to begin on the 18th, we're going to begin it on the 19th. We do jury selection in the morning. I need to remind you that your choice to represent yourself, you're making that on your own. Is that correct?
That's correct.
You understand the court can appoint an attorney to assist you?
Yes,
Yep.
is.
I know. Yeah, I know he's helping you,
Yes.
but you understand that he's not really representing you. Like, in other words, he's not doing the cross exam, direct exam.
That is correct.
All right. And you understand that while it might seem illogical, I have to, by law, require you to follow the same rules in the courtroom. Okay. So if you need to enter a piece of evidence into, an exhibit into evidence, you're asking questions, you're going to have to follow the same rules. Okay. And just make sure you say yes.
Yes.
Thank
yes.
you. Every person has a right constitutionally to due process, and every person also has the right to represent themselves. And again, I also just needed to make sure today that you are making this choice to continue without counsel. In other words, representing yourself on your own. Is that right?
That is correct. Yes.
And the key issue when I say on your own, no one's forcing you, no one's pressuring you. It's your choice.
They are not.
Okay. Copy that.
May I?
Yes, sir.
It's my understanding, Your Honor, that there's a conflict of variance in the law. Equity should prevail. I'm prepared to wrap this up and settle all of this. It can be done here in this venue. That's exclusive vertical.
Buckle up, because today's case is a full-blown sovereign citizen special. The kind where courtroom logic goes out the window and imaginary equity somehow becomes legal tender. Our star defendant, David Thompson, isn't just facing 2 charges for failure to pay child support. He's also got *2 felony drug possession counts tagging along for the ride. And here's the twist. He's decided to represent himself. Because who needs an attorney when you've got YouTube, legal theory, and confidence? But don't underestimate what's about to unfold. This judge? Calm, methodical, and not easily fazed. David? Convinced he can outsmart centuries of law with phrases like Article 3 venue. Stick around. We've got legal education, comedy, and secondhand embarrassment all rolled into one. Let's get into it.
Explain to you why, very briefly. The law and the constitutions for both the state and the United States direct that each side, and that's important, each side has the right to a trial with a jury of 12 impartial persons. And I'm really just sitting here. I don't know anything about the case other than what I see on the charge sheet, which just tells me what there's two charges of failing to pay child support.
Correct.
If you all can't negotiate that between you, I don't really get involved other than monitoring the cases and making sure I know when I've got to be here and what's going to trial. I don't get involved. And even now that we have a trial by jury, I'm not involved other than I'm telling that I run Tiger Stadium here. I mean, this courtroom, and this stadium will be available for the two parties. That's it. Okay. So I appreciate that might be your interest and that might be an objective. I can't make a ruling unless there was an appropriate motion. Now, in a criminal case, you can't file a motion to dismiss. I'm always surprised by how many attorneys, not these two gentlemen, would file a motion to dismiss in a criminal case. You can't do it. You can in a civil suit. That would be different. But here we can't do that. The law does not allow me to resolve this case unless you are all doing a trial without a jury. Since you're doing a trial with a jury, all I'm in charge of is monitoring Tiger Stadium. Okay.
Could you please repeat yourself the last two sentences, because I heard something in there. I want to make sure I heard it correctly.
Hopefully I got it right. You can't do a motion to dismiss. Well, you can in the middle of the trial when the prosecutor rests. If the prosecutor doesn't prove each element, then you can do a motion for a directed verdict pursuant to Michigan Court Rule 6.429. Either 429 or 419. I think it's 429. You can do a motion for a directed verdict at that time. Until we get there, I can't dismiss a charge. There's some other rules, like if he violates the 180-day speedy trial clock, right, and you're sitting in trial in jail. But other than that, there aren't any ways that I can dismiss the case unless this case is before me. There's no jury and it's in a trial. So if you requested and waived your right to a trial
from the start, the judge is laying down the foundation, clear, procedural, and all business. He's explaining plea deadlines, jury scheduling, and the sheer amount of work it takes to prepare for trial. It's a kind of detailed rundown every defendant should appreciate, but you can almost feel David tuning out. Sovereign citizens notoriously view structure as oppression. Even when it's just basic scheduling, he judge is being crystal clear. You can still negotiate, but after this, we're going to trial. And the fact that David's sitting there, arms crossed, waiting for his chance to drop sovereign vocabulary bombs. Yeah, you can already sense this here.
Rules that allow a district court judge or magistrate to issue an arrest warrant based upon a complaint.
Under the rules, but where does it say that in the Constitution? Because I've been reading that puppy backwards, forwards, upside down, sideways.
It doesn't. It just says it just says an arrest without a warrant is illegal. But the Michigan law doesn't. Michigan law tells us what we can do, or what. Sorry, not we, but law enforcement can do, because they don't work for me. I don't work for them. They have issued a warrant.
Right.
And they did it according to the rules.
Yes.
Yes.
And Marbury versus Madison, any law that Congress or any legislature passes, if it violates the Constitution, it's null and void on its face. I'm not here to argue. I'm just making you aware of what's happened.
It's been a long time since I had that class, which was common law, where we had to deal with Marbury versus Madison. I'm aware of it, but as of right now, there's nothing to address. So
there's a fun twist. David not only demanded a jury trial, he's also decided to act as his own lawyer. That's like jumping into a boxing ring blindfolded because you don't believe in gloves. The judge gives him multiple polite warnings. You'll have to follow every courtroom rule, file motions correctly, question witnesses properly, and handle evidence like a professional. And David? He just nods confidently, as if years of legal study and courtroom experience can be replaced by vibes and Reddit threads. The judge even double-checks that this is his choice. Spoiler, it is, and it's going to make for some grade A courtroom chaos later on.
FH, Mr. Thompson, you can come and take a seat. I don't know which attorney's handling it. So
We are David Denhouten on behalf of the people.
court recognizes the defendant, Mr. David Glenn Thompson, who is now at the defense table, and he is currently representing himself in this file. Mr. Thompson, as you might recall, I just need to go over a few things. The law requires me every time. Do you understand that you have the right to hire your own attorney?
That is correct.
And you understand that you have the right to have the court appoint an attorney to assist you if you cannot otherwise afford it?
That is correct.
And you also have the right to self-represent pursuant to the Constitution. You understand?
That is correct.
And you are electing to represent yourself. Is that correct, sir?
I am, Your Honor. Yes.
And I think you've represented yourself in this file the entire time.
Yes.
And through district court. Okay. All right. So we're here today for two things. The first is we're here today for a pretrial conference. The pretrial hearing today is just to find out where the case is going. The case probably, yes, just recently bound over to the circuit court after going through the preliminary exam phase in the district court. And I see that the felony information was filed on February 6th. And the court then subsequently issued, assume I did. Yes, a scheduling order. Or about, actually, that was done on February 5th. Even though it looks like the information was dated February 5th, but filed on the 6th. We're here again today for a pretrial conference hearing. Mr. Thompson, the only thing we do at a pretrial conference hearing is just to find out where the case is going. If there is a resolution of any kind, you guys can tell me. If not, then I'm going to ask if there are some other, I'm going to ask a couple other questions. The first thing here is see that the defendant is pending charges, and I didn't say what they were. Looks like there are 2 counts for a possession of a controlled substance. All right. Mr. Thompson, is there any resolution between this case, I'm sorry, in this case, as far as you know?
Your Honor, I believe there is.
Okay, well, hold on. I just got to ask the other party first. Because a resolution means an agreement. Mr. Denhouten, are you aware of any pretrial agreement?
I'm aware of that.
All right, thank you. That just lets me know that I've checked off that block. What do you think is the nature of the resolution then?
Your Honor, I made a deposit with an ex parte hearing regarding another matter, equity taking jurisdiction to avoid a multiplicity of suits, putting up consideration for full accord and satisfaction and settlement and closure. To my knowledge, from what I understand, it includes all matters and all liabilities related.
Yes, here it is. The Sovereign Citizen Greatest Hits album, Conflict of Laws, Equity, and Article 3 Constitutional Venue. Translation? He's reciting fragments of real legal concepts without context, trying to sound like he's discovered a secret legal loophole. Sovereign citizens often believe they can settle their cases using imaginary equity or pseudo-financial instruments, as if the court operates on monopoly money. The judge, meanwhile, keeps his composure. He's heard it all before, from "I'm not the name on the document" to "I stand under common law." This isn't new territory for him. What's impressive is his patience, because this kind of argument could easily derail a less experienced court.
That would be another one of those envelopes that you.
Yeah. I understand. Okay.
If there's any other instructions or my duty that I'm aware of, but I'm willing to correct my mistakes.
Okay. Let's take a quick look here. And you were giving me a reference to the Judicature Act, and I know it's 600, and you referenced the
576, Your Honor.
Okay. And how do you think deposit? What did specifically again? Did you deposit
a certificate of security?
Okay. And so what security was it that you tendered?
That was consideration
Or,
for any outstanding liabilities, Your Honor.
so your deposit of this certificate of security applies to, how much was it for?
That it has been unassessed and unknown at this time, which is what I'm seeking further from the court assistance in.
All right, so, and you think that somehow takes care of this particular file?
Due to the fact that where there's a conflict and variation in the law between common law and equity, Your Honor, equity shall prevail, and equity takes multiple jurisdiction to avoid a multiplicity of suits.
All right, so are you charged with the possession of controlled substances in more than one case?
No, Your Honor, that case, I was a payer, which falls into this with the 600-576. And to my knowledge, a trust running in the background deserves to be heard in equity.
So in this particular file, there isn't, you don't owe anything.
My knowledge, I do not. I have,
No, so
to
then.
my knowledge, I'm free and clear of liability, Your Honor.
No, liability is a different word. Liability doesn't apply here yet, right? There's no piece, there's no judgment that says you owe any.
The judge gives a legal masterclass in restraint here. He explains calmly that both sides have constitutional rights, not just the defendant, and that trials exist for a reason. He can't dismiss a criminal case just because someone invokes equity. Only a civil court could do that. And in Michigan, the proper procedure to challenge a weak case comes after the prosecution rests, through a motion for directed verdict under Court Rule 6.41. It's like watching a teacher gently correct a student who insists the contrast between legal logic and sovereign logic.
Charged with the same act more than once, or if you've been tried more than once, then that becomes double jeopardy. Multiplicity is something entirely different. Unless you're telling me you've been convicted of the same offense already before, which I know the answer is no.
I have not.
It's okay. So, I'm sorry, sir, I cut you off.
I do have evidence that I did deposit with the prosecutor's office of potential resolution.
Okay, so you made an offer to the prosecutor to resolve the case?
Yes, Your Honor, and I've got the
Okay.
green card resent.
That's okay. And so what happens here is I'm just the manager of this small version of Tiger Stadium.
By now, you can almost hear the collective sigh from the courtroom staff. The judge is citing exact Michigan statutes while David's clinging to YouTube law seminars. This is a defining sovereign citizen moment. They demand to know the law, and when given it, they pivot to another fantasy rulebook. The patience here is next level. The judge's Tiger Stadium analogy is especially brilliant. He's basically saying,